Attorney Parviz Malakouti, and I speak to DACA recipients every single day, whether it be on the telephone or in person at a clinic or on one of the Facebook groups. And the one thing that I come across over and over again is that DACA recipients and other dreamers want to understand more about the legal framework behind their situation. They want to understand why they are inadmissible, why they are unable to adjust status. So in this video, I'm going to show you step by step and explain to you exactly why dreamers, particularly DACA recipients, are inadmissible and are unable to adjust status. We're going to do this by going through 6 subsections of the Immigration and Nationality Act. I will be reading from the act itself so that everybody understands exactly the language that's involved. It's legalese, it's a little bit complicated, but I'm going to break down everything we read into words and sentences that anybody can understand. So that's that. If you are a DACA recipient that wants to understand the legality, the basic legal framework behind why you're in the situation that you're in, this video is for you. If you are a member of one of my immigration law classes, this is also a video for you. This is part of your lesson on inadmissibility. So without any further ado, the last thing I'll say is that this video is purely for educational purposes. This is not legal advice, and you should consult a qualified immigration lawyer about your particular situation. So that's it. Let's get into it. First of all, I'm going to minimize this screen, and we're going to pull up my screen so that you guys can see what I'm seeing, and we're going to read it all together. So where am I at? First of all, I'm at uscis.gov. I'm looking at the guidelines for DACA. Okay, so we're going to go right to the guideline that I care about for this video, which is you may request DACA if you, number 5, had no lawful status on June 15, 2012. So everybody who received DACA had no lawful status on June 15, 2012. It is one of the requirements to apply for DACA and to receive DACA. So that's our starting point. So first of all, there are two general ways for somebody to get a green card. The first is adjustment of status, which allows them to stay within the United States for the application. And the other is consular processing, which requires them to go abroad. I'm going to break down this video into 2 phases. First, I'm going to show you why a DACA recipient cannot apply for adjustment of status, unless, of course, they have a waiver of inadmissibility or another way of being able to adjust. And then secondly, I'm going to show why DACA recipients cannot go abroad for consular processing. So let's get right into it. So next step is we're going to go to INA Section 245A. That's the section of the Immigration and Nationality Act which deals with adjustment of status. This is the section. If you're wondering why it says 1255 and not 245, that's because the Immigration and Nationality Act can actually be referred to one of 2 ways. It can also be referred to as its position in the US Code, okay, 8 USC 1255. So the INA has two names actually. It can be referred to as the INA or 8 USC and then the appropriate subsection. So moving on, okay, the very first thing, okay, that it says, okay, is the status of an alien who was inspected and admitted or paroled into the United States. What does that mean? That means somebody who did not come over illegally. Inspected, okay, inspected refers to inspected by a CBP officer, okay? So the status of an alien who was inspected and admitted or paroled in the United States, okay, I'm going to skip ahead, may be adjusted by the Attorney General. May be adjusted by the Attorney General. So somebody who is admitted to the United States lawfully may adjust status. Okay, that's the general proposition. So what do we know right off the bat? If somebody came over entry without inspection, meaning if they came over illegally, if they jumped the fence or walked across the field or swam across the river and so forth, they're not able to adjust status. That's the very first thing that we just learned right here. Okay. Adjust status, of course, means apply for a green card, legal permanent residence from within the United States. Okay, so that's number 1. Okay, now, not every DACA recipient was an entry without inspection. Some of them were visa overstays. They came over, were inspected, had a visa, and then the visa expired and they stayed. Okay, what about them? Well, unfortunately, they also are unable to adjust status per INA 245 subsection C2. I'm going to go right to it. Okay, so this is C, okay? Other than an alien having an approved petition for classification as a VAWA self-petitioner, subsection A shall not be applicable to, okay, now let's pause. Subsection A shall not be applicable to, okay, what was subsection A? That's what we just read. The status of an alien who is inspected and admitted or paroled to the United States, okay, may be adjusted by the Attorney General. So subsection C is saying, okay, that subsection A does not apply to you if you fall into one of the categories that follows, okay, meaning that if you fall into one of the categories that follows, you cannot adjust status. I'm going to go right to the one that is applicable for dreamers, okay, for a large number of dreamers. 2, okay, subsection 2, okay, so it says basically, okay, subsection 2, an alien, okay, what does alien mean? It just means anybody other than a citizen. An alien other than an immediate relative as defined by section 1151B of this title. Pause. That's very important. We're going to address that later in the video, okay? That's the section that's hinting to why dreamers who are visa overstays can probably be able to adjust status if they marry a U.S. citizen without having to leave the United States. So let's pause for a second. An alien other than an immediate relative as defined in section 1151B of this title, or special immigrant described in section blah, 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 who hereafter continues in or accepts unauthorized employment, blah, blah, blah. Let's move on, okay. Or who has failed, other than through no fault of his own or for technical reasons, to maintain continuously a lawful status since entry in the United States. That's the important point. Who has failed to maintain continuously a lawful status since entry in the United States. So what does that mean? Somebody who has failed to maintain unlawful entry in the United States doesn't have subsection A applicable to them. What does subsection A says? It says they can adjust status. So putting all that together, that means that an alien who failed to maintain continuously a lawful status since entry in the United States cannot adjust status. Now, what's the very first thing we looked at in this video? Every DACA recipient had no lawful status on June 15, 2012. So if they had no lawful status on June 15, 2012, well, that means that at that point, they failed to maintain a continuous lawful status since entering the United States. Boom. That, unfortunately, makes them unable to adjust status, okay? So let's pause for a second. This is why, these two reasons, okay, an alien who is present in the United States without being admitted or inspected, or an alien who failed to continuously maintain a lawful status, they're unable to adjust status, which means apply for legal permanent residency, a green card from within the United States. Now, I said in the beginning of this video that the other way that somebody can apply for a green card is through consular processing, which requires them to leave the United States. This is where we have the issue of inadmissibility. What does inadmissibility mean? It means if you are inadmissible, it means that you cannot enter the United States, you cannot get a visa to enter the United States, and also you can't adjust status, okay? So let's analyze that right now. Why is it that a DACA recipient, if they can't adjust status, why can't they just simply leave the United States and apply for consular processing? Now, for that, we have to go to INA subsection 12A, which deals with inadmissibility. Okay, so very first line, except as otherwise provided in this chapter, aliens who are inadmissible under the following paragraphs are ineligible to receive visas and ineligible to be admitted in the United States, to the United States. Okay, that's the very first line of the subsection. That's simple. If you are inadmissible, you cannot receive a visa and you cannot be admitted into the United States. Okay, so are DACA recipients inadmissible? And the answer is most are. Some are not technically right now inadmissible, but in order to go abroad for consular processing, they would immediately become inadmissible. Let's break that down, okay? So let's go first of all to another section of INA subsection A, okay, which deals with unlawful presence, okay. Unlawful presence as inadmissibility is a very complicated topic. It gets very complex, but in a nutshell, basically unlawful presence means the time that you were present in the United States without having a lawful immigration status and being over the age of 18. So children cannot accrue unlawful status, okay? So that's what unlawful status means in a nutshell, okay? So what are we going to do? We're going to go straight to subsection INA 212A9B, okay? A9B, aliens unlawfully present, okay? In general, an alien, other than an alien lawfully admitted for permanent residence, who was unlawfully present in the United States for a period of more than 180 days, but less than 1 year, voluntarily departed the United States, okay? And again seeks admission within 3 years of the date of such alien's departure or removal. Let's break this down. What does this mean? This means that if you were unlawfully present in the United States for a period between 180 days but less than a year, that if you leave the United States, you cannot come back in within 3 years. That's called the 3-year bar, okay? Now, if you're a dreamer, if you're a DACA recipient and you're sitting here in the United States, you've had, let's say, 190 days of unlawful presence. Are you currently inadmissible based on this ground? Technically, no, because you have not yet left the United States. You're not inadmissible yet. But in order to do consular processing, you'd have to leave the United States because you have to go outside the United States to consular process. And as soon as you leave the United States, boom, the trap hits. You now have been hit with that 3-year bar. You are inadmissible back into the United States for 3 years. Okay, that's the 3-year bar. We also have a 10-year bar if you have been unlawfully present in the United States for 1 year or more. So section 2, has been unlawfully present in the United States for 1 year or more and who seeks admission within 10 years of the date of such alien's departure or removal from the United States. Same principle as the 3-year bar. It's just that if you've been unlawfully present for more than a year, you have to wait for 10 years before coming back instead of 3 years, okay? So those are the 3 and 10-year bar, okay? Now, let's go on to another very common ground of inadmissibility, okay, which we kind of spoke about a little bit, which is entry without inspection, okay? So we already said that somebody who enters the United States without inspection is unable to adjust status, okay? But they're also inadmissible. And if they're inadmissible, it means that if they go abroad for consular processing, they cannot come back into the United States because they are inadmissible. Okay, so that is INA 212A6AI. Okay, so A6AI, and it says in general. So let's read this. An alien present in the United States without being admitted or paroled or arrives in the United States at any time or place other than as designated by the Attorney General is inadmissible. What does this mean? It means if you entered without inspection, you are inadmissible. Okay, it means that if you leave the United States, you cannot get a visa to come back in the United States. You cannot come back into the United States. Okay, that closes the door on consular processing. Okay, so that's why DACA recipients are stuck under the law as we have it currently, unless they are eligible for a waiver of inadmissibility, which is a whole nother topic related to this, of course, very complex. I may do a video on that as well if there's enough appetite for it, if you guys want me to. Or remember we spoke a moment ago, or several moments ago, about DACA recipients that overstayed, okay? They did not come illegally, they did not enter without inspection, but they overstayed. Now, most of the DACA recipients who are visa overstays that I speak to understand, they kind of know that their situation's a little bit different, that there's another path available to them. They don't really understand exactly why it is. We're gonna address that right now, okay? So going back, okay, we saw here, okay, this was INA subsection 245C2, okay? This basically was showing the classes of immigrants that were unable to adjust status, okay? And we came across something here, okay, in subsections, the very beginning. It said, subject to subsection K, an alien other than an immediate relative as defined in section 1151B of this title, okay, who fails to maintain continuously a lawful status cannot adjust status. So what's this exception? This is an exception. Somebody who failed to maintain lawful immigration status but is an immediate relative, okay, of somebody defined in this section can adjust status, right? So let's explore that. Let's get into that to see what that subsection is. Okay, so it said section 1151B of this title, okay? And I have it open here. By the way, all these tabs I have open, anybody can find this in Google. Very simply, just type in the terms, the sections of the INA that I referred to in this video, and you can pull them up. I opened them up ahead of time so that I wouldn't have to fumble around during this video, okay? So let's go here. Immediate relative, B, 2AI, immediate relatives. For purposes of this subsection, the term immediate relatives means the children, spouses, and parents of a U.S. citizen of the United States. Now, if you're applying as the parent of a citizen of the United States, the child, okay, or the son or daughter has to be at least 21 years of age. Okay, that's what it says here. In the case of parents, such citizens shall be at least 21 years of age. So that means if you have a child that's a U.S. citizen and you want to use your status as an immediate relative of that child and to be able to adjust status, the child has to be at least 21 years of age. Okay, so that's why DACA recipients who are visa overstays have a little bit, I would say, easier of a path. They have another path available to them to be able to obtain legal permanent residence. Now, if you are not a visa overstay, if you're a DACA recipient that had an entry without inspection, then you need to see about the possibility of being eligible for a waiver of inadmissibility. That's a complicated area of law. I may do a video on that if there's enough of an appetite for that. So if you guys would like me to do a video on waivers of inadmissibility, explaining to you step by step the legal basis for them, just write it in the comments, let me know. And if enough of you do so, I'll make the video. Nobody should ever try to do a waiver of inadmissibility on their own. It's very complicated. It's definitely something that requires the expertise of a lawyer. It's the type of work that I do. It's the type of work that a lot of other qualified, excellent immigration lawyers do. So that's it. I hope you liked this video. Let me know in the comments if you understand this video or if it got too complicated and too confusing. That's it. Keep up the fight. I support dreamers. I support a path to legalization. Keep educating yourself, keep having fun, and stay curious. That's it.